Uh, guess we are live.
Not sure that your screen is frozen, but hi, good morning, everybody.
Designated as a so especially for organizations designated as a data fiduciary or significant data fiduciaries. So data has become the new oil, and with this superpower comes responsibilities. So organizations has categorized as significant data fiduciaries are under the spotlight to ensure that they're compliant with data privacy laws and regulations. So today we are going to explore what compliance means in this context and how organizations can navigate this complex landscape. So yeah, so let's just go ahead and so it's my pleasure to introduce our expert speaker for the today, and Dr. Preeti Jaggi ma'am, currently the DPO for Paytm Payments Bank. She has vast experience in privacy, risk, and compliance, and has worked in some of the leading tech and consulting firms. We're thrilled to have her here to share her insights on this interesting topic. Welcome, ma'am.
Great. Thank you, everybody. Good morning, and thanks, Aditya, for the warm welcome. I think yes, you started with the right stage here. That data is actually very, very important. Not only that, being as a customer, being as a user, even being as an employee. I think the entire crux or the universe of our DPDP Act itself talks about the data, the personal data of an individual. There is definitely a lot of reasons behind, and we are today going to understand that as a data fiduciaries or a significant data fiduciaries, what are the obligations which are leveled upon every organization, where they have to agree, they have to oblige by, they have to be compliant, so that they are considered to be as a DPDPA compliant. I think this is a very wonderful move which government of India have taken in enacting the our DPDP Act for on 11th of August last year. So yes, we can definitely start, and we will be going to discuss few of other definitions. Aditya, you can move to the next screen as well. So few of the definitions we are going to cover. We are going to cover the parameters based on which the any organization is considered to be as an SDF. I'll be just using SDF because significant data fiduciary will be little pretty too long, and I really wanted to speak a lot about it. And we will be discussing the obligations which is given on data fiduciaries and those additional obligation which every SDS mandatory needs to follow. Then definitely there will be the conclusions, questions forthwith we can be definitely taking up.
Thank you for the great introduction, ma'am. So before we dive in, I want to get a sense of our audience today, and type your name, anyone, in the chat, where you're from and where you're watching this from, and your name, and yeah. So let's just go ahead. So over to you, ma'am. You can
Thank you
start.
so much. I think I just started with the table of content, and the next slide we can definitely take it up. The next slide is the definitions, which talks about in a very simple language, which has been written, that what is a data fiduciary? Any organization, any entity which process the personal data of an individual. Now there are two major components to this definition. One is the processing. Another one is the personal data. Processing is everything which done to the data, whether it is your recording of the data, collecting of the data, maybe operationalizing the data, any sort of analysis which has been done the data, or even viewing the data or aggregation of data. So everything comes under the umbrella of processing. Then there is a second leg to it, which is the personal data. I think this is the major another difference between the GDPR and our DPDP Act, which is we have a personal data. a bigger umbrella under which we are covering the sensitive personal data, we are covering the PHIs, we are covering the PIIs as well. So whether it is your name, your email address, your phone numbers, your biometrics, your could be your pictures, everything comes under where you are able to recognize, where you are able to identify, even if there could be the IP, it could be the logs, which actually reaches out to an individual and identify the individual, actually comes under the personal data definition. Then there is another thing. Apart from certain parameters which makes any data fiduciaries as significant data fiduciaries, there is a section 10 which has been added where the central government can also notify that this organization will be considered to be as a data as considered to be as a SDFs. Then there is a, of course, this is the obligation which we are going to discuss. The entire webinar is based on those obligations, and we are going to discuss each obligation in a little more detailed manner. Next slide, please, Aditya. Yes, so these are the certain parameters based on which any data fiduciaries will be deemed to be considered as a significant data fiduciaries. Apart from when a government, central government itself notifies that yes, you are also a significant data fiduciary, so you have additional responsibility. One is the volume and the sensitivity of personal data. I think almost every social media giants will be considered into this kind of a category where the volume and the sensitivity, you have a profiling of your data, you have the biometrics, you have your own facial recognition of the data. So the kind of data they are processing, it makes them as a STF. Then there are other parameters like maybe any data processing or any organization which possesses a risks to the rights of data principle. So another definition of a difference between the GDPR and our DPDP Act is the definitions which we are added. We are not considered to be as a data subject, rather the user, the customer, the employee for which the data is getting processed are the data principles. I'm going little basic as well in between. So just so that we will be transparent throughout this entire webinar. So any such organization which possesses the rights to data principle, the risks to the rights, maybe there is a risk to the democracy of India, or maybe there is a risk to the public order, or any such organization where there is a integrity of India is at impactful or more impactful, or there is a security of the state is at stake. So such organizations are considered to be SDFs, so that they are also having those additional obligation which is considered to be as a mandatories for them. So next slide, Aditya, please. Thank you. So yes, we are talking a lot about obligations. So today, just now, we will be going to dig a little deeper in each and every obligations. So there's a very simple math which I follow. That what is the obligation of an SDF? This is your entire obligation of a data fiduciary plus the additional equals to the obligations of the data significant data fiduciaries. So these are the some highlighters, some pointers which we have taken, that these is kind of a mandatory for every data fiduciaries. One is the accuracy and completeness. um, a simple example, let's take a simple example. For example, if I have moved from one city to another city, and I have reached out to my bank that I wanted to update. I wanted to change my maybe my correspondence address, maybe my communication address, or a permanent address in the system in the portal. So bank should have that kind of an arrangement so that my data in the bank is actually accurate and it is complete. So this kind of a mechanism needs to be instilled in the organization. Then there is a data security. I always believe, that a privacy without security cannot work. Though the security without privacy may work if there is no personal data involved. But security starts from where the data is ingested, the data is collected, from the point data flows in an organization to the point where the data is at the end, whether data has been disposed, whether data has been at rest. throughout that journey of a data, the security of data is at most important throughout this life cycle of a data. So data security, all the organization measures, technical measures, whether you are encrypting the data, you are masking the data, all such security measures need to be, whether there is a maybe the access management control which you are putting across, maybe before reaching out to any vendors, you are analyzing the, maybe analyzing the vendor assessments. Every such security organizational measures need to be there for the data lifecycle, entire data lifecycle. Lawful processing and purpose limitation. Sorry, Aditya, we are still in the previous slide.
Still,
I'm maybe taking a little more time, but
no, no,
yes,
no,
I'm.
absolutely.
Okay, so lawful processing and purpose limitation, yes, there should be a basis on the which the processing of a data happens. For example, me as a user, I am giving a consent, or there is a contractual obligation between the organization or my own self, or there is maybe the legitimate interest of an organization. So lawful processing is utmost. Purpose limitation, I think this is a beautiful principle which needs to be instilled in every organization. The reason for which I am giving you the data should be the only reason why you are processing my data. Same example, I have moved to the different location in the bank, and maybe I have opened a locker in the bank, but now the bank should not pass on my details to a third party, maybe for credit card loan or credit card division, or even within their own department, because I have not, one, I am not aware, second, I have not taken, you have not taken my consent. So this is something which the purpose for which I am giving you my data, it should be only for that purpose that my data is getting processed. Storage limitation and data retention. I think all the organizations love to store the data. It is like that. So that there should be some kind of a limitation, unless there is a lawful jurisdiction which says that maybe the insurance data need to be kept for 8 or 10 years, maybe you have to keep the KYC data for 5 years. Some kind of a jurisdiction should be there, beyond which there should be a mechanism beyond which the data should not be retained. There should be a sort of a deletion process which is in place. There should be a sort of a deletion certificate as a proof that yes, that particular data has been deleted. Consent and privacy notice, same example. I have not given the consent to the organization for for the bank to share my data to a loan department. So I think this is the main reason here. The consent should be divided into two main categories. One should be your mandatory consent, and one should be which should be like your optional consent. In my case, in the same example, bank needs to take my KYC. So this is a mandatory consent. I have to give it to the bank, without which bank cannot open my bank account. Now there is an optional consent. I do not want the bank to maybe pass on my data for marketing, sales, growth, analytics, and all. So I am not giving the consent for that. So this kind of a consent verification should be given to the data principals. I should have a right to decide whether I want all the maybe the services of the banks, and I'm taking it across on the optional consent, or I'm not. I'm just fixed to my mandatory consent. Privacy notice, it has been added together only for the one reason that why I'm giving a consent based on what I'm able to read through the privacy notice, that what the bank is going to process my data, what kind of a third party is getting involved, how the security measures of the bank is happening. So the entire details discussion should be there in the privacy notice, so that I am able to take a decision. Data deletion and data disposal, just now we spoke that after the data, beyond this data retention, there should be a mechanism for the data deletion with the data certificate, so that we will have a proof that yes, the data has been deleted. Data principal rights management, yes. Whether it is a right to access, whether it is a right to correct, whether it's a right to having an erasure of a data, right to nominate of the data, whether right to grievance redressal, the every organization, whether you are a data fiduciary or whether you are an STF, you need to have a certain grievance redressal mechanism. And I believe there is no need, much need to reinvent the wheel. The reason being that most of the organizations already have a customer service team. and they have their customer service team where there is a complaints and the processes which is happening through. So you just have to put one leg to the DPO office, and there's such grievances related to the rights of a data subject, data principles, such grievances related to the personal data should be moved towards that particular division. Children data processing, yes, I think this is one of the great aspect which has been added here. One is every personal data of an individual below the 18 years of age is considered to be as a child, and without the lawful consent of a parents or the lawful guardians, you cannot process the data. Organizations cannot process the data, and even if you got a consent, there should not be such processing that is detrimental to the well-being of a child. So I don't know how many of us would know about. There was a long back. There was a game, some online game which came across as a blue whale, and due to
Yeah.
owing to there is lot of children who actually has reached to the end of their life even. So such detrimental processings of the data where you are actually profiling the children, you're actually doing those kind of a neural analysis on the children's decision. It definitely needs to be stopped at once. So this is very important for the every child. Data processor and contractual, I think this is another important thing. As an organization, we do not have a separate obligation for the data processor in the DPDP Act, which means that only there is a one way where me as an organization can bind the other vendors or third party is through the contracts. So all those obligations which is leveled, whether it is depending whether it is an accuracy, whether it is a purpose limitation, whether it is a data deletion certification, all such obligation needs to be bind in the contractual, which you may call it as a DPA, which is a data processing agreements. And for the retrospective vendors or even for the future vendors, you need to have this address in an organization, so that not only my obligation is shared, rather I am also sure as an organization that those vendors will also follow the DPDPA compliant. The last is the compliance with that. Yes, this is the definitely umbrella. We all are here because we wanted to understand how the organization need to put across certain parameters to be compliant with the act. Yes, Aditya, we can move to the next slide now. Yes, additional obligations as we have discussed, all the obligations which we discuss now, plus these three additional obligations is actually the sum total where the significant data fiduciary obligations need to be established. One is your SDF need to be having a DPO established in India. So I think this is very 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 good. We can take like example. There are many MNCs which have a DPO office in outside India, and they have their branches in India. But if they are categorized as an SDF, you need to have one of the DPO sitting here in India. So this is another important aspect which I have seen, that your DPO should be in India. You cannot run the DPO office from being sitting outside the India. Second is that there should be the independent streak of a DPO. The individual, the DPO who's been in charge of the entire DPO office, who's considered to be DPO office, should be accountable to the board of directors. And he should also be the part or a point of contact for the grievance redressal mechanism. Just now, when I stated that there should be one leg should move out directly to the DPO office, this is what I was speaking about. So another part is your conducting your data protection impact analysis. I think this is, even if you are you are a data fiduciary, I believe that DPIA should be processed. The reason being that you will able to understand that with the data flow, with the kind of processing happening in an organization, what is the potential harm and how you can mitigate those risks, how you can manage those risks. It could be an operational risk, it could be maybe the policy related risk, it could be some technical measures you want to introduce. So DPIA is really important, and I think every organization should go through once by the DPIA before. For SDFs, yes, it is mandatory. Then there is an independent data auditor. Apart from knowing what a DPO is, how the DPO is running the entire DPO office, there should be one independent auditor who's actually reviewing, who's auditing, who is trying to find out if there is any better way we can do it. So that independence should be given, and there should be an external auditor hired. Maybe I'm not sure what will the duration. Is it a maybe for every annual year, or it could be maybe after 6 months? So these rules are yet to be released, and I think we all are waiting for that. So that independent auditor is really important to have in an organization. So next slide, Aditya. I think I have added this slide and this slide together, and we can move to the next slide as well. A conclusion, yes. There is. We all know what kind of penalties which the data protection board may level to us, depending upon the kind of God forbid any kind of a failure which happens to the under the obligations. So I think with this we can definitely conclude, and I am happy to take the questions forthwith. Aditya, you please wanted to add anything? Please feel free to add.
Absolutely, ma'am. I think one question here is pretty interesting from Navneet Sharma from New Delhi, and he's asking us if what is the threshold of an SDF designation, and is there a numerical or a qualitative threshold? So now I think this is very interesting because in our experience, we've seen several organizations struggle with identifying as significant data fiduciaries, and what criterias would you say are the most in terms of what is more challenging for these companies? It's basically very challenging for them to assess. So in my observation, I've noticed that many organizations are uncertain about the volume of data that they handle and whether it crosses a threshold that qualifies them as a significant data fiduciary. So often there's a lack of clarity on what constitutes even personal data to that extent, and leading to confusion about their obligations. So even your views on in terms of what is a numerical or a qualitative threshold. So what do
Absolutely
you?
right. So Aditya, I think that's a very valid question, and this is even the question which I wanted to understand. Right now, the we are all waiting for the rules so that we will have a some kind of a numerical, justification. Maybe is it like a 25 lakhs plus, kind of a consumers we are having, or maybe so. This is for sure that the sensitivity of data we can definitely analyze on that. We do not require the numerical conclusion on that. For example, if I'm using the lot of biometric data, if I'm doing a lot of analytics, if I'm profiling that customer data, and this is my crux of the processing is depending upon those profiling, those aggregation, and that sensitivity of data, definitely that I'll be considered to be as an SDF. Volume, like just I gave an example of, it could be the social media giants, it could be those banks which are from the legacy, the older sort of a banks which have the every in fact every household have an account in those particular banks. So those numerical, as of now the threshold has not been decided. I'm really hoping that during the rules there should be some kind of a percentage or some kind of a maybe like lakhs of customer, this much millions of a customer should be given, so that it is very easy for all the organization to identify that yes, I come in that category, I am an SDF. As of now, Mr. Navneet, there is a kind of a rough estimation which is reaching out to everybody.
Also, a follow-up question to that that just came to me is when it comes to ensuring compliance, we found that one of the key challenges is integrating data protection measures into existing systems. So, how do you suggest that organizations tackle this? So, for example, a common issue is with legacy systems which weren't built for current data protection compliances
Absolutely.
in mind, and implementing these data encryption across border database, or across border, or even with older databases, or how do you these are like complex and very intensive tasks. So what do you think could be a good way to sort of tackle these, or any points that come off your mind? Just you could give us an insight on that.
Definitely, Aditya. Aditya, I think we are in a very good era now. I started, working with data privacy with GDPR before even the inception. Back then, there was no such tools. Everything was Excel and Word for me. So Even to understand that whether my organization is controller or processor, there used to be roundtable conferences. So now I think we have matured enough. But going back to your question, this is the first thing ever any organization have to do or any DP office have to do is to understand the data, even if the retrospective data, how where I'm getting this data, how many different divisions are there in my organization. Maybe there are 10, maybe there are 50 products in a particular organization. Under each product, what are the data sets which I'm using, from where the data set is coming. So I think the first and foremost stage is you should have a data inventory. Your data flow diagrams should be in place so that you can correlate where exactly data is going. So okay, after this division, after maybe the number division 3, my data goes to the third party. So which basically means your vendor risk assessments, your third party tools, your third party assessment is required to understand the risk. So it that the moment you are completed with the data flow till the end, and any organization currently measures that is the reason I told that without security we cannot achieve privacy. It is very important to have a proper handshake throughout the data which goes across with the infosec team, with the IT team, to understand the vulnerabilities, to understand what exactly happens, to understand the vulnerabilities, to understand what happens with the data, where the data goes at rest, what happens, are we using any encryption while transferring the data, what kind of APIs we are using. So this is something which is important not only for the future but even for the retrospective. For the retrospective, as of now, it is really important that every organization should understand what is happening with the data, where my data is coming, where it goes. The moment we are cleared with this kind of a concept, because data is coming across through like a rain, you are analyzing, there's an analytical team, there's a profiling team, there's a data aggregation happening, there's a statistical team who's actually giving, there's a sales team, marketing team, there's all different sort of tools you are using. What kind of tools you are using? Are you using any AI driven tools? If AI driven tools are there, what sort of a AI analysis of what sort of a DPIE on the AI analysis tools has been done, whether the biasness has been reviewed, or whether those checks has been done. What happened, is it, are you using any open tool, source tool? So I think that kind of a homework needs to be done. Unless until we complete that, it is not possible that we will have those data security measures in place.
Thank you so much, ma'am. Navneet Sharma has asked a follow-up question. It is understood that digital competition bill is yet to be passed by the parliament. Once passed, what will be the interface or overlap between DPDPA and DCB, if any? So basically, what's the overlap between like a competition law concept and data privacy concept? So any ideas, ma'am, on this?
I think Mr. Navneet have taken this really, really well, because this is another question which I was thinking through, that what could be the delta and what could be the I think the similarity will be on the similar basis, that even if we are passing through the digital competition bill, there should be the privacy measures which should be taken into consideration. There should be the security measures. I think the similarity from the organization perspective should be the DPIA. It should be mandatory for every organization to conclude that, to understand what is happening with the data, where any processing of a data goes through a which goes through that kind of a maybe where is a delta, what is the difference. So Mr. Navneet, right now, as of now, if I'll be very honest here, I have not done this kind of a complete homework to answer you on that, but definitely I'll be connecting with you through Sarva, and I will be answering you this question to the complete details.
Also, I think uh, best practices for data fiduciary
Yes,
compliance can also vary across industries. So, even with respect to competition law, I think in the financial sector, for instance, we've seen strong emphasis on transaction monitoring and on encryption protocols. Whereas in healthcare, there is more on consent management systems. And so also even within the industries, there could be a lot varying, and that could also impact the overlap between DPDP and the competition law. Is
exactly,
what
Aditya. So this,
an idea.
adding to this, Aditya, absolutely correct. That is the reason. It again depends upon industry, but the basic remains the same. The basic is that I should know that what kind of a processing I'm doing and what is harming to that particular data. So that that potential harm impact analysis is required to be done. I think that is one of the point which every industry will be following. And yes, you're to the point. You're absolutely correct here that every industry depends upon every industry. There need to be the main prioritized obligation, and there could be the semi-prioritized obligation. So yes, Mr. Navneet, this is hope we're trying to answer your question here.
Uh, so I think that's I think very well put, ma'am. And we've had a pretty informative session. Just to summarize, basically the key takeaways is we've covered a range of topics from sort of defining and starting with what is a significant data fiduciary, what's the difference between a data fiduciary and a significant data fiduciary, and how do we move on with, first of all, understanding some of the key aspects in how to recognize yourself as as a significant data fiduciary, and also with respect to a few questions that came our way, as in what could be the overlap and how could we take this across different industries, because there are tech companies, there are fintech companies, there are healthcare companies, which all come under the category of a significant data fiduciary, and yet have different, could have different, a little bit of a different compliance varying according to their own industry standards. So uh, I hope you all found this session very insightful, and a big thank you to you, ma'am, Preeti, ma'am, for sharing your expertise with us today, and to all of you for your active participation. Your engagement is what makes this truly valuable. So I think so. Before we wrap up, I'd like to ask everyone to just maybe put in the chat as to thumbs up, or just you could write your biggest takeaway or any specific takeaway that you liked, and any other questions if you have. We can take this up in the next session as well. Um, so I think, yeah. So thank you once again, everyone, for joining us, and we look forward to seeing you at our future webinars. And have a great
Thank you,
day.
Aditya. Thank you, Aditya and Saro Group, for calling me here, and thank you everyone who's been here. And I think let's join our hands together and make sure that we are compliant towards the DPDP Act, and let's share each one's the best practices so that we all are actually being compliant over the DPDP Act. Thank you, everyone, and have a great weekend.
Thank you, ma'am. You too.
Thank you. Bye bye.